Good evening, sir. Thank you so much for coming to the podcast. So, you have been almost 27 years now. You have been practicing litigation in intellectual property law. So, we're going to obviously discuss about that. Uh, let's try to make this as easier to understand for the audience because law is something that not a lot of people can understand because the wordings and the technicalities are bit much for them. So we'll try to break it down as much as we can as we go through. And in the latest section of the podcast, we'll be discussing about the very popular case that is for a past week is going on in the media. So we will come to that. So I want to start with what exactly intellectual property means for someone who is, for example, let's just say starting a YouTube channel, a business, they have some product that they have created. So, what intellectual property basically means for them? What is the definition?
Firstly, thanks, Divyansh, for having me on this podcast. I'm very glad, as usual, very happy to speak about intellectual property. What 1 hour I can speak for 5 hours on it for free. So no problem at all. But I think, like you have physical property, intellectual property is a property right which is intangible or incorporeal. There's no physical aspect to it, but there are rights. And within this whole technical term of intellectual property, you have different intellectual property species or rights. You have trademarks, brands, McDonald brand or Coca-Cola brand or Tata brand. You have copyrights, which are books, which have subdivisions. You have design rights, which is the aesthetic features of any product, a nice shaped bonnet of a car, the shape of a watch, etc. You can have design rights, registration design rights, and you have patents which are inventions, a molecule for a drug, a software that interacts with hardware to make the hardware run better, software that pixelates your screen better, stuff like that. So invention, mechanical inventions, software, technology inventions. So all of these fall under intellectual property rights. More specifically to copyrights, copyrights essentially are creations of human expression, human creativity, right? And they start with the written word, right? And the written word was the first form of human beings expressing themselves. If you look at music, I think it was some maybe 4,000, 14,000 years ago, Sumerian tablet, which had some musical notes on it. So music as a expressive output existed thousands of years ago, and there's archaeological evidence. And so you have different copyright species within the copyright nomenclature. So you can have literary works, which are books, the written text. You have musical composition, which is the melody of the tune, right? Now, in the interesting thing about musical compositions is in the West, musical compositions are annotated. There's a whole way of writing out. But in India, our music tradition is oral. So, for instance, under Indian copyright law, there's no written requirement or fixation requirement for a musical composition to be copyrighted because all based on rags and so it's all we had an oral tradition, right? So there's music. Apart from literary works, musical works, there's dramatic works, which is the script and yeah, the play, the script of a theatrical play. You have computer programs or software, which is again a copyrighted work. Then come, so these works, so literary works, musical works, artistic works, artwork, drawings, engravings, sculptures, all of that. They're all artistic work. And then you have musical, dramatic works. These are all results of the human mind, creative expressions of human beings, right? Now, all of these can come together and form this podcast you're shooting is classified as a cinematograph film, right? And the soundtrack that you're recording with the visual of this podcast is classified as a sound recording, right? So original literary, dramatic, artistic, musical works which come from human beings, and the collective or derivatives of these, which are films and sound recordings, all found under the copyright description. Now, copyrights, it's a strange thing that copyrights started actually being protected around the 17th century, right? One of the first copyright laws was the Statute of Queen Anne in the 1700s in England, where they said, look, these books are being sold, they are endeavors and results of a lot of creativity and hard work and skill and judgment and creative output. We must protect them. So there was a limited, I think, 5 or 25 year protection, I forget which, in the 1700s. In 1846, that became 50 years. So books were the first to be protected. Now, the disciplines of copyright differ. There are many theories within copyright. What England and hence India follow is the economic model of copyright protection.
Okay, so the economic value attached to
Economic
that
value.
intellectual property
Correct.
is around that the law is
Correct.
based. Yeah.
Effectively, what the law in these countries says, copyright is actually a negative right. It's my right to prevent anybody else.
A negative right.
Negative right. It's
yeah.
known as a species of a negative right.
Mm-hmm.
It's my right to prevent anybody else from using what
Yeah.
I have created.
Yeah.
Particularly in certain respects, not everything.
Mm-hmm.
But if you reproduce my work,
Hmm.
somebody copies your podcast and reproduces and produces it on another channel or another platform, that's a reproduction. If they don't have a license, it's an infringement because they didn't. So your reproduction is one. Communicating it to the public is one. That other right could mean that they've taken it, reproduced it, and have now disseminated it and made it available for people to listen to without your permission. Communication is one.
Yeah.
So there are about 7-8 rights for literary work, about 5 or 6 rights for different types of works for different uses. And artistic works.
Yeah.
I will violate somebody's artistic right if I copy a 2D drawing into 2D, or if I convert a 2D drawing into a 3D object, I'll violate the copyright.
Okay.
So these are negative rights where copyrights are concerned. Interestingly, in the civil law countries like France, they reject the notion of copyright. They call it author's right.
Author's right.
Yeah. Because in the Commonwealth countries, the tradition was the economic interest and businesses that purchased the results of what human beings created to monetize them. So all these economic rights that I told you, these exclusive rights, were concentrated around publishers.
Okay,
music companies.
They were the ones who
They were the
used
ones
to
who
monetize
monetize the rights.
author's creation, right?
France was different. France rejected the notion of copyright and they said authors will have prime place. The creator will have a prime place. And so everything flows out of the author's right system in France. They have the same, almost the same rights as the Commonwealth system has, but it is author centric.
Yeah.
To the extent where if you travel to Germany, assignments are not allowed.
Okay.
Because the title goes away from the author. So the world has developed according to, there's no single notion which is 100% uniform of copyright across the world.
Okay.
So the rules of creation, the rules of ownership, the rules of what you can do or can't do differ by jurisdiction.
Yeah.
That's the tragedy and beauty of copyright, you know.
Yeah, that's good. So I just had a follow-up question with that one, what you were saying regarding the copyright law in India. You said that it's not okay. Let's just say I have a blog or I have something that I have created, and someone else. You said that you reproduce someone else's work. So the basic act of reproducing violates the copyright, or like when it gets a economic value to it. For example, I have created something and other person copies it and tries to monetize it. That act of monetization violates the copyright, or just basically creating it will just violate?
That's a very important question, because the normal misnomer or misunderstanding is if I don't make money, I don't violate your copyright.
Exactly.
That's incorrect. In almost all conditions, except for a very few limited conditions, if you exercise my exclusive right, that's it.
Yeah.
without my consent.
Hmm.
And in India, the consent has to be in writing, no
Okay.
oral license.
Okay.
This was all put in place to protect the creator.
Yeah.
Because a powerful person, an industry would take away rights
Yeah.
and would not remunerate the creator.
Hmm.
And so, whether you monetize it or not is irrelevant. If you have exercised my exclusive right,
Hmm.
the criteria, very interestingly, a court in Bombay once said in 1989, the criteria would the author have been paid for what you did. Not whether you made money or not.
Hmm.
But under normal conditions, would you, by taking my license, would I have charged you for it or not? Under normal conditions.
Yeah.
Now, the only way to answer that question is yes. Because to say no would be to presume
Yeah.
too much.
Yeah.
So, that criteria is, the reason for that is that when you have a creation of your set of creative expression, or the output or the result of your creative expression, the exercise of certain rights is reserved to the owner of that copyright.
Yeah.
Whether you monetize it or not is secondary. The primary infringement or the primary infraction, जिसको बोलते हैं,
Hmm.
comes out when you exercise my exclusive right without my license or permission in writing in India.
Okay. So
That's it.
basically, the first act itself will
Correct.
violate the copyright
Correct.
of the
Correct.
author. Yeah. So, okay, the natural follow up to this is the repercussions that follow when a copyright is intellectual property is violated. And this economic angle, which I asked just before, you know why I asked it, because I want to connect it to the issue which we're going to talk in a bit. So, okay, so violations. I want to talk about violations, and while talking about that, I also want to talk about the exclusivity of a property. Okay, so one thing is basic, that if as you said a while ago, that if the rights are violated, it's up to the author will have to decide as to there is no consent, you did not take consent from me, you have violated the law. So obviously there's going to be some repercussions. It can be a monetary value, it can be whatever the law suggests. So how does that come into flow, the violations, and how, like, what rights does the author have to compensate the loss that he has faced?
See, under normal conditions, if you infringe my copyright under Indian law, I have either or both of two options. One is to institute a civil proceeding against you for restraining further violation and for recompense in terms of damages. That's one option. The second option is a criminal proceeding,
Yeah.
which is effectively, because of what the Supreme Court reconfirmed 2-3 years ago, is a non-bailable offense.
Okay.
Yes, it's a
Yeah.
non-bailable offense. It's 3 years imprisonment at the worst, with or without fine. So these are not elective remedies in the sense that it's not as if you have to choose one of the two.
Okay.
You can do both
The author
at the same time. Yes, the author or the owner.
or the owner. Yeah, the
Correct?
owner.
So you can do both, and both will proceed parallel. In parallel, these are parallel remedies, not elective remedies. Primarily because by the civil case you will get compensation and restraint. The criminal case, because an offence has occurred, there will be a
Punishment attached
it's
to
an
it.
economic
Yeah.
offence, so there will be a punishment for that. So these are the basic remedies that are available from a sort of a vanilla copyright
Yeah.
enforcement perspective.
Yeah. And the courts decide, like it is
Courts will
up to
decide.
the courts
Yes.
to decide, the judge to
Yeah.
decide what, how much it has to be done.
There are various modalities for how damages could be calculated.
Yeah.
On damage, the most common modality is on any of normal God's given days, what would I issue, what money would I take to issue a license, right?
Yeah.
That's your comparable license royalty rate, plus an infringement fee or an infringement impact sort of consequence, depending on was it willful, how egregious it was, how whether that person had no knowledge, etc., etc. There could be compensatory damages plus punitive damages on top of that. In India, compared to America, if say 10 rupees is the damage, your punitive damage can't be more than 10 rupees. So it's 20 rupees total, right? So that's the basic modality of calculation.
Yeah. And just the third question to regarding understanding this more, and then we'll move on to the issue, and then we'll unravel things. Is that okay? So copyright violation has been done, and courts have found a person guilty in that, and whatever the repercussions you told will follow as per the rules and norms. Uh, it's also there must there has to be in this case also that it's up to the creator to decide the severity of the punishment, because let's just say that he or she decides to, okay, the violations have been done, and the person is ready to pay the fine, but person can have change of heart and he can say that, okay, I don't want the punishment to be this severe. Something less can be done. Or this kind of situations, does the creator did they do that, or it's just up to the court to decide? It doesn't matter if you have a change of heart. Okay, I'll just go a bit deeper into this. Let's just say he has to pay a crore fine, 1 crore rupees fine in violating that property. The courts have decided this, and the creator says that no, I don't want it to be this severe. 50 lakhs can be done. I don't want it 1 crore. 50 lakhs can be done, and let's just let the person go. Does this happen, or it is almost on the court to decide, and they have decided, and it's done in that
Oh,
way?
no, the court's role is only to decide what the court feels on the basis of certain facts, what the consequences should be. Any creator or any author or owner of copyright in Latin, lawyers love using Latin terms because a
Yeah.
lot of our law comes from what is known as the Roman Justinian Code and all of that. So one of the terms is dominus litis. That is, the plaintiff is the dominant person and they decide. So you could have a situation where while the case is midstream, the plaintiff could tell a civil court that I don't wish to continue with this. It's not within, and I want to withdraw. I've settled. And the court does not have a role there apart from saying, why did you waste my time? And sort of imposing some degree of cost for the public time of the court being wasted. Court can't prevent a withdrawal of that case. That's one scenario. Second scenario is where judgment comes and the court said, okay, you pay 1 crore. And notwithstanding the 1 crore, both parties agree that you will pay 30 lakhs. Right? The matter can be settled and closed and discharged there. That 1 crore has no practical effect. Because ultimately, you have to understand in law what happens is a judgment comes. And then the plaintiff, as the person who holds the judgment in the hand, has to go to execute the judgment under an execution petition to recover that money.
Okay.
So it's not as if a judgment comes and I'm automatically liable. Court is
Okay.
not concerned after the judgment. Now it is on the plaintiff to file an execution petition to recover money.
the money.
So there's a whole process: judgment debtor, judgment creditor. The defendant will be a judgment debtor, and the plaintiff will be the decree holder there. He will enforce the judgment. The court will look at the execution petition, will not go into the correctness or wrong, validity or invalidity of judgment. Will look at the decree, will ask for a list of properties, bank balances, all that to find, and then we'll look at the decretal amount and will issue what is known as a warrant of attachment, and then the decree amount is satisfied. So if 1 crore is owed, the person has a 20 crore property, it's not like 20 crores will be sold off. The amount will be satisfied. If the person can satisfy without the property being sold, he say, okay, I'll pay 1 crore upfront, the decree is satisfied. At that time, if both parties decide to settle, done. No problem. Court has no role. So it's not as if on the criminal side, because these are non-bailable cognizable cases, you can't compound and close the case before, say, a magistrate's court or before the court of session. You have to go to the High Court and ask for the FIR to be quashed on a settlement, private settlement. And you can settle that matter primarily because this is not a case of fraud in a bank, which affects the public at large. It's essentially a private crime impacting one or between two properties, right? So courts will generally not stand in the way of quashing those matters. So it's not as if once I've let the arrow loose, I don't know, I can't do anything. The plaintiff and the owner is completely in control in the riding seat. It depends on them how much they want to harass anybody. or feel fairly recover what they want, the color of litigations can change. It can be a tool of harassment, a tool of subjugation, and a tool of compensation, depending on the intention.
Yeah. And it's fair to say that courts are basically a mediator in this, in between two parties. Let's just to settle the issue.
The court is an adjudicator.
Adjudicator. Okay.
Yeah.
Got it.
You generally have a chance in now copyright matters, IP matters in Delhi. There's something called pre-litigation mediation. So before I go to court to get an injunction, unless I meet the opposite party says, I don't want to mediate with you,
Okay.
rejects mediation. I can go straight to court and say, look, I tried mediation, but they've refused.
Okay.
But there's a mandatory pre-litigation mediation requirement under the Commercial Courts Act, IP, in Delhi and other courts. First, I have to go to a mediator in the High Court.
Okay.
The mediator tries to sort it out. And then if that does not work, then the parties go to litigation. So it's not as if, unless the opposite party has said no, you know,
But it is a mandate that they need to go through mediation.
they need to go
Yeah.
unless the opposite party
Yeah,
said,
yeah.
I'm not willing to pay you, I reject. So he said, if he's already rejected my claim, then what's the point?
The call needs to be taken. Like
A call
if there
needs
is
to be taken.
needs to be mediation or not.
Again,
Fair.
here what we are talking about is nuances.
Yeah.
You know what they say?
Yeah.
They say religion needs priests and the law needs lawyers to interpret both. Yeah.
Okay.
So the problem is that both these types of clergies become interpreters of what is essentially very simple to people to understand.
Yeah.
And unfortunately, what happens because of these two types of clergies, people don't take the trouble to
Yeah,
understand
trouble
for
to-
themselves.
Exactly. Yeah, that's true. What role does the state has to play, whether if there is a copyright violation, or does it have a role in or not?
No role at all.
No role at
No
all.
role whatsoever.
Okay, no role at all.
No role whatsoever.
Okay, that's fair.
It's a private right.
Private right. Got
The
it.
state's remit started and ended when it proposed the law, and legislature in its wisdom says we approve the law, and then the state notified the law, then you're on your own. Parties can go and complain to government that XYZ is misusing its ability or misusing. All the state's role is that if the state has some level of leverage with that party or with that entity to say that, well, if you are not going to be decent about it, the benefit you draw from us will not be provided to you because what you are doing is irresponsible, we feel,
Yeah.
entirely up to you. State will never compel anybody, but the state will make a request saying, don't do this.
Yeah.
And if they're sensible, they'll listen. If they're not, and they decide, then if there's consequences, not consequences, the state will have no further punitive role there. The state can be a mediator at best in a private rights situation. They won't have a determinative role.
Yeah. Okay, so I guess we have talked about the basics of it. Like obviously there's too much
Let's
in
get the
detail.
heart of the matter.
Yeah. Okay. So now we can I'll just give a brief context of what we're going to talk about. So two parties basically. Okay, on a lighter note, can we name the parties
You
because
can name them.
will
I'm
that
not a
be
lawyer
copyright
in any
violation?
matter.
Okay.
I'm sure we all respect the courts. The objective of this podcast is not to
No, not really.
is not to criticize any proceeding, but within the fundamental freedom of speech framework, you have the ability to critique a party's posture and stand before a court,
Yeah.
to critique the nature of the law, to critique the nature of the proceedings, and I dare say even critique any court order as well.
Okay.
In fact, some of the more wise judges say that I don't know why people get upset about judges being criticized. You should, if you feel that way, you should read the first two grounds of every appeal. Because the first two grounds of every appeal accuse a judge against whose order or judgment is being appealed against of things like perversity. This judgment is perverse. The learned judge failed to apply his mind and stuff like that, which is standard appellate law language used in grounds. So you should feel free to critique judgments, courts, and their judgments. What they say is, in Latin again, when arguments become ad hominem or personal, is when you cross into the right
Yeah.
of. So no
Yeah.
problem.
Okay.
That's fair.
That's fair. If I violate anything that I have a
I'll stop
IP
you.
law,
Don't
yeah.
worry.
Okay. That's good. That's okay. Now we can talk. So okay, the context is basically I'll just take 2 minutes to explain. So ANI is a news agency, not a news channel. Let's just make that distinction because we'll come to that. ANI is a news agency that has been collecting news for years now, and a YouTuber, Mohak Mangal, uh, has made a case in the Delhi High Court, if I'm not wrong. So the issue was he had used a 9 second and an 11 second clip
Yeah.
of certain news that ANI had captured or posted in a video, in an explainer video that he made on his channel. So ANI, in response, gave copyright strikes on 2 of his videos, and as YouTube policy says that a third strike, which will mean the channel will be shut. So in response, Mohak Mangal comes up with the video. He calls out ANI, and he also shows some recordings of an ANI agent, mediator, whatever, NI person who is talking to the team of Mohak Mangal and is saying that if you want this to stop, you have used our video without our consent, without our permission in your video. You're trying to monetize it, so that means a copyright infringement. Now you have to pay a fine. The amount stated is 48 lakhs, if I'm not wrong, in the beginning. Then they say that if you want to stop this, you need to take a subscription, just like other news channels that have subscriptions of ANI. They pay ANI to take the news that they have gathered and show on their channel. Just like that, you need to take that subscription for 2 years. You need to pay this money. Further negotiations take place, and they pull down the amount and they say, okay, 40 lakhs, let's just say. But Mohak makes a video and calls out ANI, and he says that we're going to court. This is unfair because a fair use policy says that we can use the video. He talks about the length of the video. We'll come to that as well because there's a technicality there as well. So this is basically ANI in response also goes to court. They're saying that this is our copyright infringement and we need to we have the right to demand this money. The case is still going on. It's an ongoing process. We'll have updates soon. What I want to start with is firstly, is there a copyright violation taken place in this matter?
So I'm afraid this is one answer I'll duck, but for a very valid reason, not from a lawyer instinct perspective. I haven't seen those videos.
Okay.
I believe those videos were taken down. I've
Yes,
been telling
yes.
a lot of people, have you seen those videos? And a lot of people who are criticizing one party either way have not even seen those videos.
Yeah.
So I said the circumstance of use is not before you. I would hesitate to sort of even classify what either has done from a copyright infringement perspective. I don't know the specifics of that case. So I'm happy to speak about the surrounding law. And kind of give you my thoughts, and then you can ask me more questions.
Yeah. Okay, just we can just change the question in a bit so it is easier for you to answer. Let's just say I have made a video on certain topic.
Yes.
Okay, and I have put my money. It's my camera. It's my team. I recorded a video. Let's just say I recorded the speech of the Prime Minister. I have the exclusive footage of that. Let's just say, and I, as a business model, what I do is other people can come to me and they say, hey Divyansh, I want to give you 100 rupees for this video so that I can use it. I want to show it to other people. Okay. I say, okay, that's fine. Pay me the money. You can use the video. This is basic business that I have created. Okay. Now a third person comes to me. He takes the video. He does not come to me in the first place. Takes the video from somewhere, uses it, tries to monetize it. And there was no communication done with me. This is my side of the story. So is that a violation?
So first, I think a good place to start is, what is our concept of copyright? When we started, I told you what copyright is, etc., etc. So there are two sort of misconceptions. One, I think this misconception of copyright as a monopoly right is a misconception.
Okay, yeah, I want to talk about that too.
Inbuilt within the Copyright Act are various foils which are, in terms of limitations and exceptions to copyright infringement, right? So they're inbuilt. We will talk about
specific
that.
Section 52, if I'm not wrong.
Correct.
It lists
Yes,
off
the intention is to keep the copyright owner honest and decent in terms of being unreasonable.
Yeah.
in terms of being rapacious,
Hmm.
in terms of being abusive. Um, American copyright law has a defense called copyright misuse.
Okay.
India does not have it. This was tried in an Indian court.
Okay.
Delhi High Court a couple of years back said, so sorry,
Hmm.
wish it is,
Hmm.
but our copyright law does not have a copyright misuse
Misuse.
defense. I can actually go and have a defense in America saying you're misusing your copyright.
Okay.
Yes.
Hmm.
So India does not have
Hmm.
that. But there are checks and balances on copyright owners,
Hmm.
right? To the extent where uh, you may have to spend money
Hmm.
in creating content,
Hmm.
but there are certain situations under which you might have spent crores of rupees developing that content, irrespective of how valuable your content is. If the context of that use fits a purpose, if the purpose of use
Hmm.
meets the what is set down under the fair dealing
Hmm. Hmm.
provisions of Indian
Hmm.
law, then it is not an infringement.
Okay.
Example,
Yeah.
you and I hypothetically are discussing a famous singer,
Hmm.
and we are talking about the singer's singing style,
Hmm.
vocal pitch, and other technical aspects and career graph,
Hmm.
etc. And you play 10 seconds,
Hmm.
15 second snippets
Of that song.
of that
Hmm.
person's different songs. And in the middle, I say, oh, you saw that high pitch, you saw that pitch that they took, you see that voice. We're talking about Kumar Gandhar compared with another great classical singer. And I tell you, did you know that Kumar Gandhar had only one lung, which is why his notes were shorter, and he would not have elongated longer notes than compared with his contemporaries. But he was a more radical. He didn't want to play by the rules of classical that much. So his whole singing style during when he was alive was criticized. But look at how great he is, and so we are criticizing that person, and the owner of that music sends you a legal notice and says you use 15 seconds, give me money. If the context and purpose of your use is for criticism, then there's no way the owner of copyright can sustain that claim. The purpose has to fit. That is what fair dealing is. So, fair dealing for the purpose of research, review, let's start with the language. Fair dealing for the purpose of um, personal or private use, including research, criticism or review, reporting current affairs or newsworthy, or including a lecture made in public. These are fair dealing defenses. So, two criteria: fair dealing. We'll talk about fair dealing later. So, it has to amount to fair dealing for this purpose: research, criticism, review, reporting on news, current affairs. Right? What is fair dealing? Fair dealing, again, we are beneficiaries of the Commonwealth system and English law, and our erstwhile English overlords left us with this form of copyright law. Fair dealing effectively means please be fair. An example would be, can I reproduce the entire poem and talk about you as a writer? Court said in England and in India, you don't have to reproduce the entire work. You can use some paragraphs, right, and then talk about the style. And you didn't need the entire work. I think Prince Albert had some wives he had letters he had written to his wife, and I think the Times or one of those tabloid papers chapot the entire in all the letters. So in a copyright claim, the English High Court said you didn't have to print all the letters. You could have used excerpts and then talked about the relationship between the husband and the wife, but you didn't need to produce the letters. So I think that very aptly describes fair dealing. The more modern trend is for Indian courts to use the four-fold factors, the four factors from American law, the fair use law. Now, again, people say fair use, fair use. Fair use is an American dictum. In India, Section 52 of the Copyright Act says fair dealing, and then until ZB or ZC goes on to enumerate fact and use case specific instances where it is an exception. Fair dealing is not used apart from section 52(1)(a).
Yeah.
Fair dealing is, you won't find the term anywhere else. But it will say, if a sound recording is played
Yes.
in a residential hostel for the purpose, for the benefit of the residents, it's not an
Yeah,
infringement.
they've taken scenarios,
Yeah.
real life examples
Yeah.
to explain
But not in a
what.
commercial
Yeah, yeah, yeah,
establishment,
yeah.
not in a hotel room. That's not exception. That will be infringement. But in a residential hostel, done, no problem. If I use artistic work in a cinematograph film, where the artistic work is not the main objective of the film, then it's not an infringement. You see?
Yeah.
So this 52 is so vast, apart
Yeah.
from the fair dealing provision, that if you don't slot there, if you slot under fair dealing and you meet the purpose, then there is no basis. Here, what is defeated the purpose is, in my personal view, it's not 3 copyright strikes, it's 3 copyright strikes within 90 days.
Okay.
So what copyright owners do, they're strategic,
Yeah.
they wait,
Hmm.
they let you add videos, then they'll do 1 copyright strike, they'll send you a letter, they'll do a 2nd copyright strike, then they'll send you a legal notice, then they will hold the nicely supplied YouTube process,
Yeah.
that in 90 days, the 3rd strike, your channel goes, you're banned.
Yeah.
So they will use that as a process. Now, what could save you is YouTube becoming a judge on its own platform, saying, no, we don't agree, it's infringement, it's fair dealing. Ironically.
Yeah.
So the judge here is not the Indian court, it's YouTube, who says that, no, I don't think. So you have to then go to YouTube and say, please, appeal process. So that is not Indian law. It's that process that you're a slave to. The YouTube process.
The policy is
3
that
strikes
YouTube
in
has-
90 days, you're out.
Hmm.
Why not 10 strikes in 90 days? Why is 3 a number to show me that I'm a recidivist, as you say, habitual criminal or habitual violator? Why not 2? Why not 5?
Yeah.
Who decided 3? Are you taking from US law, the 3 strikes law, that if you are convicted or you're caught 3 times, then your jail term will be exponentially higher in California and Texas and the other states? So there's no logic, I feel. And YouTube has no business banning people, because individual pieces of content can be taken down.
Not the entire channel.
No, then you
Yeah.
go to a court and get damages. But if you're getting off a channel, what is he going to fight in court?
Yeah. Because
That's one perspective.
yeah.
The other perspective is, if you're a YouTube creator and you're making money from advertising revenue, why do you think YouTube pays you advertising revenue? What is the basis? Example, I take a Alamara or whatever, one of those old films, which are not protected by copyright law now,
Yeah.
and I play them on YouTube. You think YouTube will monetize that video? Even if YouTube monetizes that video, you think YouTube will pay you, the channel owner who's uploaded that video, any money? No. Because YouTube effectively is paying you for the copyright ownership that you have in that video you create and upload, which is why they have to pay you advertising revenue.
Okay.
You understand?
That's because so
Effectively,
yeah.
why
Yeah,
would
yeah.
YouTube pay you advertising revenue on your video?
Because I am the copyright owner of that
Copyright
content that I have
owner, you
uploaded.
benefit
Yeah.
from that by advertising revenue. I'd like a share of that.
Yeah. Yeah. Because that's my creation.
So if you are
Essentially.
benefiting from copyright, and we don't realize we are benefiting from copyright, then respecting copyright is, I feel, a small thing. But at the same time, YouTube creators who have created a business around content, it boggles my imagination sometimes that if you're sensible about and spend money on branding, this, that, then be sensible about the legal part of your business.
Yeah.
I've repeated this example ad nauseum. If you and I save money and are going to buy a house, you look at the title deed, are you not going to think, let me वकील से बात
Let me
कर
talk to
लेते
the
हैं,
lawyer. हाँ.
ये डॉक्यूमेंट ठीक है कि नहीं, टाइटल देख
Exactly.
लेते हैं लोकल म्यूनिसिपैलिटी में, तहसीलदार में, ये
Hmm.
इनका है कि नहीं,
Hmm.
करेक्ट
Yeah,
ना,
yeah.
यहाँ के
That's
लिए.
pretty much basic
तो
requirement of that.
मैंने जब
Yeah.
when I started I said no, tangible property and intangible property,
Yeah.
the respect with which you treat both should not differ.
Hmm.
So due diligence you do in both.
Hmm.
Without the due diligence, I think one can complain about, and again, let me say, it's not a question of somebody having a right and asserting a right.
Hmm.
Obviously, copyrights can be abused.
Yeah.
I mean, sitting here in my personal view, where you had a license for 5 lakhs and you asked for 50 lakhs, it's insane to do a 10x up value in terms of the damages you demand from somebody. It's crazy. What is the basis of 50 lakhs when your normal license fee is 5 lakhs?
Yeah.
15 lakhs, 20 lakhs, but why 50 lakhs?
10 times more. Yeah.
Right? So, it's a combination, I feel, of various things. For ANI, it's a monetization channel. They've realized that you should give licenses to my subscribers. My subscribers are television channels. Because OTT, they're taking eyeballs from my subscribers.
Yeah.
They're making money. Let me make money. So some bright sparkle said, 50 lakh, we'll ask for 50 lakhs.
That
We'll
is,
get it.
Can we call it a basic business? Like
Of
just
course.
yeah.
It's
So-
a business.
Yeah.
ENI is a copyright business at the end of the day.
Yeah. Yeah.
It's not, I mean, let's not make the mistake of painting anybody with a sort of a heavenly brush, so to speak, in terms of, oh no, you are creating content. So, I'm sorry, it's a subscription-based business.
Yeah.
They develop copyright because there's a business interest,
Yeah.
there's a profit motive. It's a profit-making business that rests on an important intellectual property right recognized by our law. That's one side. YouTube creators create content which is copyrighted content which they can monetize, and they do monetize. So in creating that, they need to be cognizant of any third-party copyright.
Yeah.
And I see a lot of YouTube creators who are very aware of copyright content. No music in this.
Yeah.
If you can clear the rights. I don't know, years back you remember AIB
Yeah.
asked YRF for some rights and
Yeah.
they didn't. So they came out with this whole diss track which became a viral hit.
Yeah. But they
I think
use
it was
the-
more, if not
Yeah.
more as important, as viral as the song itself.
Yeah. Of course. Yeah,
Is it?
I have heard that song. Yeah.
So they are aware of the third party content. On the news side, nobody thinks about, oh, I'll take a clip from a news channel and use it. Then you realize that, no. The Times of India newspaper I read every day, there's a copyright there. They own copyright in the news content. To what extent they own copyright in the news content if you divorce the facts and the fact that facts are not copyrightable? A lot of their content is, example, uh, in the recent Operation Sindoor social media clips, which almost every media agency was playing. If a YouTuber took one of those social media clips and played it, just because their imprint is there on that video, they could claim a copyright. You have to show copyright ownership. So I send 300 stringers to do different government functions. Nobody wants to invest in that business, so I do it. They go, they play it. He comes and gives the video. But when ANI or any copyright owner has to assert that copyright, if they can't produce the Mr. XYZ, who's my cameraman, he's my employee, and he made this film at my behest. I'm the owner of that film because I paid for the creation of that film. If I can't show the document of ownership,
Yeah. Then
I don't have copyright to assert.
And in that case, that claim will not stand in court.
It will not stand in court. It will not stand anywhere.
Anywhere. Yeah. Yesterday, just to tell you what has happened, ANI they have come up with a podcast on their channel, ANI podcast, in which their standing counsel in court, I don't remember the name.
Siddhant Kumar.
Yeah, exactly. So he has explained their side of the story.
I haven't seen that.
I got to see that episode in which he has explained their side of the story of why they are claiming this and how the things are going in court and what rights do they have for asking that amount of money. Very interesting point they came along, and you also touched it, in which you said that suppose the event is happening, ANI puts its resources, they put their money where nobody else wants to go. In YouTube, what these people are making these educational videos, they explainer videos, they take this content from news agencies, news channels. They are not going there themselves to record that in that particular event they are not the investors, they don't send their team, they use these videos. So common sense says that they need to pay the subscription, they need to pay the money. In this case it has not been done, so basically what means is ANI has the right to demand that money from in which the copyright has been violated, right?
From a humorous perspective, when you start talking about common sense in the law in the same breath, then we are in trouble.
Okay.
Because common sense certainly suggests that when a business invests money and creates content, then you have to use it, you have to pay for it. But I'm afraid that that's not the mandate of the law.
Okay.
The general mandate of the law, yes, you must pay for it, except in certain situations which we, the legislator, have deemed, or the legislative body, whose wisdom of the legislative body, have deemed that you cannot claim copyright infringement, i.e. you cannot claim violation or money, if I'm using it for news purposes and it only amounts to fair dealing.
Okay.
You can't claim money. It's not a moral issue, it's a legal issue. And the legal issue is, if you and I are sitting here and we do fair dealing in using small excerpts and focus it for that purpose and can show the court that the purpose is for news and current affairs reporting or for review or criticism, right? Then a court will find in my favor, not in favor of the copyright owner. Because the court will say the legislature has said in this law that your mandate ends here. The legal mandate, the statute, your copyright ownership ends here. I am not militating or fighting against the basic common sense argument. If I invest and I create something, then I must be able to monetize it. No question then, fair enough. But when you say that, you should know that the law says thus far and no further.
Okay.
In these situations, if this is the criteria of use. That criteria of use is again fair dealing in a manner in for the purpose of research, review, criticism, personal use, right? Private use, personal use, research, reporting on current events. Simple.
Okay. I have a question. Let's just say the person who is using that content is able to justify all these points, fair dealing point. He is able to justify that, okay, this comes under fair dealing, but monetization comes into play. Let's just say that, okay, he or she or a certain party, they have used a clip, they have used the creator's content, who has the right to owner, and they have used it for the purpose of criticism, commentary, or whatever the fair dealing criteria whatever criteria comes under fair dealing, but they have also monetized that video that they have made using that clip.
Yes.
Okay, so does that comes under violation or not?
In
Or
certain
will
respect,
that come into fair dealing?
No, it's a very important question.
Yeah.
I think it's irrelevant for the purpose of review and criticism and reporting on current affairs. It might apply, monetization or commercialization might apply where research is concerned, for instance. Private use including for research. But where criticism and review is concerned, doesn't matter.
Okay.
I may monetize, I may make 10 crores of that.
Okay.
But the fact is, when the law says this physical activity does not amount to fair dealing, then the question of me monetizing, not monetizing is irrelevant.
Sorry, I want to just understand it
Yes,
more.
let's break it down.
Yeah, let's break it down. What I want to
If I engage in fair dealing for a limited excerpt of that content for the purposes of criticizing or reviewing a certain situation related to that content that is there, or I am talking about a current event, you see that language in the statute is not reporting on news. Reporting on current affairs and current events. It's broader.
Yeah.
That news would be there's been a train accident
Hmm.
and I'm using the clip and I'm talking within the same day
Yeah.
of the train accident, not 15 days later. But current affairs, current events is a broader term.
Yeah.
It's not contemporaneous. It's not
Because current event is not defined by a
a
period.
broader term.
Yeah, it's a broader term.
Now, in that, if I'm making that content and I'm selling that content, it's no problem.
Okay.
It does not matter. Just because I'm monetizing the fact of monetization, then the legislator would have said irrespective. It's a the legislative body has limited the draft of that statute, that provision, to reporting on current affairs. Just because commercialization comes in is not a criteria
matter.
for the court to say, no, you made money, so I will.
Okay, so basically,
How will I report on current events without making money?
yeah, true.
News laundry is a business.
Yeah,
It's a business.
Yeah. So basically, if fair dealing is justified, doesn't matter if you make money on that or
Yeah.
not. It does not come under
Yes.
copyright violation.
Research might be a different thing altogether.
Okay.
I might research a molecule. When I make it into a drug and start selling it, that's a different thing altogether. You see, you have to see where it stops.
Yeah. There is certain lines that that are drawn here.
Yeah.
Okay. Taking this case, for example, the ANI versus the YouTuber case, let's just say, because I want to understand this law more, let's just say Mohak Mangal is not able to justify the fair dealing. Okay, that the clip that he has used, fair dealing is not justified. So now ANI, the money that they're demanding, it's within their rights to demand the money, whatever the amount that is. Like, okay, you said that morality comes in and we can ask that, okay, why demand so much money? Doesn't matter, 50 क्यों मांगना है, 10 से भी हो सकता था. But the law says that it is the right of the owner to demand whatever, damages. Okay. So that's their right. ANI has the right to do that because, okay, the law gives them the power. Another aspect that they were discussing about...
Demanding is not getting,
Okay.
just to clarify.
Yeah.
It's the court that will decide what is the appropriate damages.
Okay.
The plaintiff can demand. The plaintiff has to justify. The court is to decide what is appropriate.
Okay. So I'll just break it down as well. So let's just say ANI is saying that we want 50 lakh rupees.
Yes.
And they have made their claims for that.
They made that
But
claim.
the court finds that no, 50 lakh is not justified for this claim. And
Yes.
they say that for this claim, let's just say 20 lakhs is justified.
Yes.
So that 20 lakhs amount will stand.
Correct.
50 lakhs goes into...
50
goes out the
lakhs
window.
won't matter.
Okay. So courts can come
Yes,
into this.
court
It's
will.
Not, okay, court will come into
Yes.
this. Okay.
If Mr. Mohak Mandal does not defend himself, then the court will say, okay, fine, I'll use my own criteria. Mr. Mohak Mandal has stopped appearing. For instance, hypothetically, I understand that's not the case, but assuming, suppose he were to stop defending himself and be set ex parte by the court, and the court proceeds with the ANI claim. ANI continues to press 50 lakh. The court will say, what is the basis of your asking for 50 lakh? What are your comparable license rates? That is one criteria.
Yes, that's interesting.
What is the commensurate damages that should be granted in this case? Damages, the definition of damages means loss. I have suffered a loss.
So they need to
You've
justify
gained.
that amount that they have lost.
Yeah.
You
One
know-
criteria for damages would be I sell my product under my IP at 10 rupees. You are selling it for 13 rupees.
Okay.
Right? Is my damage 13 rupees or 10 rupees? 10 rupees.
Yeah.
Rendition of accounts of profits, what profits you made. Right?
Yeah.
So if your business is very profitable, then I'll get a portion of the profits. Damages would be how many of those 13 rupee products have you sold? And because of your sale, have you replaced my market so my 10 rupee product wouldn't be sold? There's a lovely case which
Yeah.
got overturned in appeal. You know, you have the English Time magazine.
Yeah.
Some enterprising gentleman wrote Time magazine in Devanagari, Time, and he published about, I think, 40 or 45 or 100 copies of an Indian Time magazine
Okay.
with Hindi Time, no authority, no life, no connection. So Time magazine sued. And the judge granted some 5 lakhs. And in that, only one issue was published. And in that one issue, there was a rate card
Okay.
for advertisements. And the rate card totaled to a certain number, I forget now, a certain number of lakhs. And The court said, well, the defendant has stopped appearing. This rate card is there, one issue is there, there's advertisement there, this the money is made, this is the damages.
Okay.
When it went up, the appellate court disagreed. Said that's certainly no way to calculate damages. Eventually, in other cases, the court said we disagree with that calculation. It has to be tested.
Okay.
It cannot be penal. Damages is a civil claim. You cannot have a penal quality to it. You can't break somebody's back. The objective is damages is put ANI in the place it was before Mohak Mangal's violation occurred.
Yeah. Okay.
That's a simple principle.
Yeah. And that's
Plus a little bit on top
Yeah.
in terms of if Mohak Mandal was given a notice, he said, egregious, willful violation as opposed to normal violation. There's no excuse under Indian law for innocent infringement to the extent where injunction will still follow. Damages may be drawn down if you can show it was innocent.
So another aspect that came out in this conversation was that there's also a policy in the YouTube guidelines, if I'm not wrong, that in a certain video, and two questions related to that. The two questions are asked in one. So the video is made, whatever, let's just say the copyright infringement has been done. Okay, so there is copyright infringement. And the person that has done this act, he says that, okay, it is my fault. Let's just say it is my fault. You can take the action you want. There's also a criteria that that particular channel, whatever the amount of that particular video, whatever amount that video has generated, the revenue that video has generated, it can be given into the copyright owner's account. Or whatever money that video has been
demonetization
done.
and then
the revenue for that video goes with the okay. This aspect is there. So the people say that why not use this aspect? Why shut the entire channel? The question I want to ask is, does this right to claim just one video's revenue or the entire channel? Who gets to decide this?
YouTube.
Okay.
It's the platform. The platform shuts your channel down. The platform decides in its wisdom whether something is fair use or not. The channel decides, and they say publicly we don't, but I beg to disagree.
Okay.
Channel decides that instead of infringing content, if there are 3 strikes in 90 days, I will remove your channel or have the power to remove your channel. Let's be accurate. I have the power to remove your channel. I suspect not everybody's channel is removed. But I have the power to remove your channel. It's not an automated process. There's a human editorial function which says, hata do. And if that's the case, then Indian law does not support this level of power being given to an intermediary. The trade-off for a YouTube, which is an intermediary, under the law, is you will not hold me liable for Ameet Datta's rubbish content, which is illegal, as long as you give me YouTube a notice and tell me to take it down if it violates copyright. I will take it down in 36 hours or whatever. Or if the police gives me a authorized agency under the IT Act gives me a notice, I will take it down. Or I get a court order and I take it down. As long as I comply with the takedown in these 3 instances, YouTube will not be held liable as a company for Ameet Datta's acts. But if I disregard these 3 notices, right, these 3 types, any of these 3, then along with Ameet Datta, YouTube will also be held liable as much as Ameet Datta is abatement. That's the law under Section 79 of the Information Technology Act. It's called the intermediary safe harbor. So a safe harbor was crafted for
intermediary.
So YouTube is an intermediary. Amazon is an intermediary. You and I go, we are sellers, we load items. You order from me. You think you're ordering a phone, I send you a brick. Who's liable? Amazon or Ameet? The law says, as long as Amazon takes steps as an intermediary and Amazon is not directly sort of facilitating it, Ameet Datta is liable. Same way YouTube is not first flush not liable for copyright infringement. ANI gives a notice, they take down the content, YouTube is not liable, Ameet Datta continues being liable, or Mohak Mangal continues being liable. So that's now a private matter between them.
Between A and I.
Right.
Yeah.
That's the law.
Hmm.
MySpace and T-Series fought a long litigation. In 2017, there was a MySpace judgment where the court said, please identify the location URL by URL.
Hmm.
And MySpace will, once it can identify, and please give your basis of your ownership. And MySpace has a liability to take down each URL.
Yeah.
Correct?
Okay.
MySpace was not being blocked, no?
Yeah.
Huh? So how is YouTube blocking a channel?
Yeah, that's interesting. So
The entire channel.
yeah.
I give you another example. There are BitTorrent and Torrent and CyberLocker sitting outside the country. They upload millions of hours of pirated films.
Yeah.
They offer it to people here who download them. They don't come to India, but they still make money
Yeah.
on PayPal and all sorts of payment. Now, how do you stop them? Can you go to millions of URLs? Right? So, the law is, and there are hundreds of judgments, but there's a UTV judgment years ago where the court said, get a technical expert, sit down and assess this website. If an overwhelming portion of this website is infringing material, right, then it's a rogue operation, it's a pirate website. The whole website in that case can be banned. But just because there are 100 links on Vimeo or Google groups of infringing content does not take away from the fact that there is a mass of non-infringing content also there. So I will not allow the blocking of the portal. Individual URLs will be blocked. Now, if that's the law, and the only time you can block a website is if majority of the content is infringing, under what basis? But it's a private basis. But where is the legal sanction for YouTube to say, I will block the entire channel?
Yes, exactly.
If
That's
3
interesting.
videos are infringing from 200 videos or 20 videos.
Yeah. So
You see, that's the logic. So, my objection has less to do with ANI's 50 lakh demand
more with
or
YouTube.
Mohak Mangal's inability to be sensible, in my view, to do due diligence when putting up content, to have a professional outfit when he's got 4.5 million subscribers and hundreds of millions of views, but more with the fact that YouTube plays God
Yeah, exactly. In this
and
case,
judge and jury and executioner
all in one.
and disappears your entire content and channel on 3 instances.
On 3 instances.
On a 3-strike rule, which is not the basis of Indian law. And so that in itself is problematic where I am concerned.
Hypothetically speaking, let's just say that YouTube says that 3 strikes on 3 videos means those 3 videos will be deleted from YouTube. YouTube will delete those 3 videos because the 3 strikes have been done. Would that have been...
Fair enough.
Yeah, okay. Not the entire
No,
channel.
the law must be upheld.
Yeah.
YouTube's only remit should be, I have received a takedown of copyright notice. I'm sorry, Mohak, boss. I like you a lot as a person, but I'll have to remove this video.
Yeah, that's fair.
I'm not getting into whether this video is infringing or not. That's your baby with the copyright
That's
claimant.
court to decide.
It's not my role to sit as a judge.
If you think that this act
Correct.
is wrong, go to court.
Correct.
Yeah, okay.
In fairness, YouTube is allowed to do that in America. It operates under the fair use doctrine.
Okay.
It cites its servers in the US. And for uniformity's perspective, obviously it can't break up its technology model on a country-wise basis. It can't, like in a Russia, the censorship will be worse. In Pakistan, they tell you, ki, switch off kar do in 10 logo ko, abhi. You know, so without recourse. Or in another country, it might be different. So they can't operate in a fragmented perspective. That whole system is criticism worthy from an Indian perspective, but we have to also understand that it's a transnational company. It's got a transnational technology platform, and it has to find ways to best work, right? But I believe that in India or anywhere else, this 3-strike rule is the tool to suppress free speech. Not the government, not a copyright owner, but this unwitting tool of three strikes and removing a channel is a massive chilling effect on every YouTube creator. It's very, very, I think it's damaging to the YouTube ecosystem. Perhaps in the future, fatally so. Because there is less and less room for views that one does not agree with. And rightly so, all types of tools are available to attack those views. Copyright is only one of those tools. I'm not saying that ANI has done that. ANI is monetizing it. But assuming one were to use it for a political objective, then the law does not allow you to do that. It allows you certainly to use it video to video, URL to URL. But YouTube is providing the biggest tool which Indian law does not even prescribe.
Okay. Just an add-on question. Could AI have done, this is hypothetical basically. Yeah, okay, this is fairly out there that this 3 strikes policy is the problem. That 3 strikes on 3 videos, the entire channel goes down. Can this be a case, I'm talking about the possibility of it, that ANI wants to give 2 strikes on 2 videos, and ANI says that I want the revenue of these 2 videos. And YouTube says, okay, you can take this, or YouTube says, no, that's not our policy. Like,
oh yeah, they can. I mean, in the sense that I don't know, I have to confess, I don't know how the monetization shift works
fair.
and what are the criteria determining that. But I'm assuming that ANI could benefit from monetization. And it would be interesting because if ANI does assume for monetization of those videos, then how that would affect his damages claim would be interesting.
Okay. Yeah. That's
yeah. So you've got compensation from there. It's like double dipping, no?
Yeah. That will be interesting. Okay.
So it'll be interesting to see that. Honestly, I feel this could have been done better, perhaps. And I'll tell you, hindsight is always 20/20.
Yeah.
But I believe that the YouTube ecosystem is a very fair monetization ecosystem for ANI. It has valuable content. There's no question about it. It should be monetizing it. I'm surprised they took so long, frankly. They should have been perhaps as reasonable as they have been with the television industry. Built out a rate card and subscription rates, advertised it to people, and then gone and started licensing. I also believe that this issue, I think they're reading a lot too much into it. It's not like ANI is some dark star or Death Star like in Star Wars, waiting to annihilate copyright creators. They're not crazy. They're running a business. If people don't want to use the content, it's their loss.
Yes.
There's no gain in stopping people using their content. I believe, and let me point out, when in the beginning when you pointed out that there was a recorded conversation, I've seen that video very carefully. You have to be very fair about this. If you look carefully at that video where the recorded conversation going on the top left, you will see recreated conversation written there.
Okay.
That recorded conversation is not the conversation, in my understanding. And please have a look at that video again. It's not the conversation that occurred between the ANI person and
Mohak's
the gentleman's team. It's a recreated conversation
of what supposedly would have
Yes.
been in that call. Okay.
And to me, it's apparent more so when you listen to what the gentleman in ANI, there's not a natural voice. It's, you see, it's,
I get it.
I think it's AI generated, synth voice, whatever it is. But if you look at that video itself, you will have, there's a legend there clearly on Mr. Mangal's, it's recreated recording on the top left. So I noticed that. I said this recording is sounding very artificial.
Yeah.
It's not. It's not a organic conversation. People cough. There's sounds at the back and 10 different things. It's not like a sound studio conversation, right?
Yeah.
But so from that, then I noticed that recreated recording.
it can be said from his side that
So
okay.
I don't know what was said and what was not said.
Got it.
I
Got it.
think that's very
Yeah.
important to keep in mind.
Yeah, I get it. Okay, fair. So, okay, very interestingly, where does free speech come into all this? Is this act whatever ANI has done? Let's just say this copyright infringement, what they have claimed, and Mohak's act of using that video and all of this that has been gone. Does free speech come into this at all, or if it does, how? Like, is this a free speech issue?
To be honest, not where ANI's claim is concerned, but certainly in the YouTube policy, I believe there's a tap-on effect and a negative effect on free speech
Okay.
because there's a
Yes.
chilling aspect indirectly. I don't believe ANI asking for a viable, non-viable demand. At maximum, a video could have been taken down. Just a few months ago, barely a month ago, the Delhi High Court said against a copyright owner, where the copyright owner's claim is unreasonable, then it amounts to withholding from the public, then you can go get a compulsory license from the court for content.
Okay.
Every copyright owner needs to be careful about one issue, that I can claim a lot of money from people, but in certain situations, if I start claiming unreasonable amounts, some parts of the law for certain types of usage allow people to go get a compulsory license will be a rate fixed by a court.
Okay, break it down
So
a bit. Yeah.
there's the so-called monopoly right copyright
Yeah.
law.
Yeah.
There's limitation on copyright and exceptions to copyright. Exceptions we've discussed, fair dealing and the other
Yeah.
provisions. This limitation is, the limitations on copyright is, you can assert your copyright, you will get compensation, but you will not decide what as the copyright owner, you will not decide it. A court or a tribunal will decide it. Because you have withheld your work, or you have unreasonably claimed, you have refused to negotiate in good faith for certain types of usage. Whether this fits in or not is a different matter.
That's
So, the law recognizes two types of limitations. And where licenses are concerned, three types of licenses. Limitations are number one, compulsory license. Number two, statutory license. Right? Three types of licenses exist. Voluntary license, I can claim 50 lakhs from you. Compulsory license, where you and I, you want to use my work. I say I want 50 lakhs. You say nothing doing, it's unreasonable. You go to the court and said he's made an unreasonable thing for me to use this content, he's withheld it. And the court says yes, he's withheld it. It won't be 50 lakhs, it will be 5 lakhs.
that.
And the rate going forward for your content is 5 lakhs.
The court will decide that.
Court will
Yeah.
decide. And I'm stuck with that value.
Okay.
So that's one downside. There is another third situation with the statutory license, where you and I don't need to talk to each other. Radio stations. Radio station goes to the court saying, I'm a radio station. I want a statutory license. Please fix rates for music broadcast. And the court says for the next year, this is the rate.
Based on certain
For
calculations.
underlying works and for sound recording, this is the rate.
Okay.
So compulsory license requires you and me to interact and the relationship to break for you to go. Statutory license does not require it. It's a statutory license. So these three types of copyright owners need to be careful there also.
That copyright owners can't just blatantly fix
Yeah.
an amount of money to their creation.
Having said that, it's not as if every situation is covered
Yeah,
under compulsory license.
that's
Every
true.
situation, no. But in the situations that do, you should be very careful that I should not be demanding too much. The market doesn't support. People have this option, and people have gone. And when they start using this option, then I'll be out of pocket. Maybe with a willing buyer, willing seller discussion and paradigm, I could have from 50 lakhs done it at 12 lakhs. I would have still made more than 5 lakhs, or I would have made 20 lakhs or 30 lakhs, whatever it is. So even that situation is there. So they need to be careful about that. So which is why I say copyright is a monopoly, right?
Yeah.
It's a slight bit of a misnomer because there are checks and balances. And free speech, copyright certainly can become, trademark can become a basis for a free speech violation.
Okay.
It can.
Okay.
I understand ANI has filed a second suit, I think today or something like that. There they made a trademark claim also.
Okay.
That you use my ANI logo in the video. From what I read.
Okay.
Apart from copyright, they've done a trademark infringement claim. Now, there's a very interesting case called Greenpeace. The firm I used to previously work with, Sai Krishna Rajgopal, the managing partner, a fantastic lawyer. He argued this case. The case essentially was Greenpeace, there's Damra port in Odisha. Greenpeace was worried about the ecological damage to the olive ridley turtles. They were upset. The Tatas at that time held that port.
It's
They
a very
made a
famous case.
Pac-Man.
Yeah.
They made a Pac-Man game.
Yeah.
And they called that thing Ratty for Ratan Tata, the late Ratan Tata, the great Ratan Tata. And obviously, they sued.
Yeah.
The court said, it's not trademark infringement. They also sued for trademark. So they said, no, it's hyperbole, defamation. So there are bases they are called SLAP suits. These are strategic litigation against public participation. So SLAP suits are used as a legal device to stop inconvenient reporting. And SLAP suits can be based on defamation. It can be based on trade libel, which is a species of defamation, trademark infringement, copyright infringement, and other violations. And celebrated cases, the Gawker case in America, where Gawker was a very well-known online investigative tabloid type report, sensationalist reporting. Years ago, they reported on Peter Thiel.
Yeah. Okay.
Years ago. And they reported on Hulk Hogan, the WWE wrestler.
Yeah.
And Hulk Hogan sued them for damages. Peter Thiel funded Hulk Hogan.
Peter Thiel, Facebook, right? Yeah.
PayPal.
Oh yeah. Okay. Got it.
PayPal.
He also get it.
Peter Thiel apparently, reportedly funded Hulk Hogan in the litigation. That litigation ended with Gawker closing.
Okay.
You understand?
Yeah.
IP was not the issue here. Defamation.
Defamation.
So, defamation, intellectual property certainly can be used as tools against free speech. Whether this case is a case of free speech, I highly doubt it's a free speech case. Copyright law makes room for free speech. Copyright law is suborned to and substituted to free speech. Being prevented, and how? News, current reporting, research, review, criticism.
That's free speech, yeah. The exceptions of copyright infringement, yeah, that's interesting. Okay. Okay, a lot. This is an ongoing case. More details will be coming as this case proceeds. So, I want to talk about another case that you had in 2012, if I'm not wrong, regarding the Indian music industry. You fought. There was a after which the amendment was copyright amendment. What? Let's just talk a bit about what happened there. What was that about?
India was a strange country until 2012 because, unlike the rest of the world, the people who created music, after the initial payment, got no money. And as technology developed and more sources of income developed, creators still didn't get money. Revenue streams and royalty streams increased. YouTube came and radio came, mobile came, television came. Author composers, creators never got money.
It was just the one-time payment.
Yes.
Right.
And Javed Saab led that fight. I was fortunate enough to be one of the people to assist him on that fight. And the entire aspect was, we reviewed hundreds, more than maybe 1 or 2,000 music creator agreements and lyricist agreements from the late 50s to 2008-7, from the great Bharat Ratna, Pandit Ravi Shankar, to Grammy Award, Oscar winner, A.R. Rahman, to everybody. And not one of these artists had negotiated a holdback. That I'm not giving you these rights. For mobile, I will not give you. For TV, I will not give you. That to us, from an economic perspective, suggested that there was a monopsony in the market. There was market asymmetry. There were few gatekeepers. There were lots of sellers. Gatekeepers were not allowing access to the market. And the amendment, which was unanimous, every political party supported it.
Okay.
Every political party. Led to India now being the only country where the creator of lyrics and music is reserved and guaranteed a 50% equal share of royalty from any exploitation of that music, whether it's a part of a film or a sound recording or otherwise. And even more, the creator is not allowed to assign it to anybody.
Okay.
A film producer, music label can't say, you are assigning me 100% of everything. And I don't have to give you, after this payment, I don't have to give you 1 rupee. I'll give you 10 rupees, I'll make 1 million rupees from it. I don't have to
give
share
anything.
that.
Yeah.
They can't take it. The author cannot waive that right,
Even if he wants to, he
even if
cannot.
he wants
Okay.
to.
Okay.
And if he's forced to, because the understanding is that when you're in an industry with businesses, there's predatory contracting, so you don't have a choice. And the result is, if there is a contract, then the law treats the contract as void.
Okay.
And without a written assignment, there's no right.
Yeah.
Right. So that has resulted in, and then after that amendment came, the law was like that, and then Minister Piyush Goyal, the Commerce and Industry Minister, he got involved, and IPRS is the Copyright Society today for author composers and music publishers. A lot of the disputes that were going on, they were settled, and after they were settled, IPRS was re-registered. It was earning 42 crores in 2017. This year they've distributed 600 crores to creators. It had 4,000, less than 5,000 members in 2016. Today it has 17,000 members. So this is the one instance I say I'm lucky to be, and lucky to have been a part of a law change where in my lifetime I can see the positive benefit of a good law.
Okay.
And India, I'm proud to say, and we must be very proud, India is the only country in the world that protects creators in the fashion it protects.
Okay.
There is no other country with a parallel
That's
of
a
this
fact.
law.
Yeah.
Fact.
Okay.
Well researched fact. Germany prevents assignments. Nobody protects the money interest. So today you can take 100%, you can take assignment from Javed Akhtar or from Guldar Saab or from anybody. But that 50% money interest you can't take.
Yeah. That has
That
to
a
go to them.
copyright society can collect. And so that is what copyright
Yeah.
is.
Yeah.
Without the economic interest, the negative right has little meaning. Because once I exercise the negative right, I can exercise it to benefit economically. So that in itself is ground changing, and the industry is not suffered. It's only grown.
Okay. Yeah. With that change.
So thereby the apprehension in 2012, oh, the industry will suffer, and because we were not this, and now more stakeholders. So even singers are getting money now, royalties.
Yeah.
Music industry is collecting and paying them. So India is part of, not only part of the mainstream, I would argue, exponentially ahead
Forerunners
with
of-
copyright law.
Yeah. Okay. One question. Let's just keep IP law for a side because you have been in this profession for so long. I have just one question regarding just basic law to understand, which I have been thinking for a lot of times. I think this. Generally, contempt of court. What does it mean? What things a normal person can do which will mean that you are in contempt of court?
You know, there are basically two types of contempt. One is a contempt that a party to a litigation under an injunction disobeys the injunction. That's contempt
That's fair.
under the Code of Civil Procedure. Then there is Contempt of Courts Act 1971. There are different species of contempt there. Civil contempt and criminal contempt.
Okay.
Civil contempt is again where, for instance, there's a litigation going on and I make statements about the ethics of a judge in order to call into disrepute the judicial process or call into question the impartiality of a judge by alleging bias and all. That might amount to contempt of court. Um, there are instances where people have misbehaved with judges. That is contempt on the face of the court. Punishable by imprisonment. Both civil and criminal contempt are punishable by civil imprisonment. Criminal contempt is far more stronger.
Okay.
But the Contempt of Court Act in itself clarifies that it's not contempt for a journalist, for instance, to report on the proceedings in a case,
Okay, it's not a contempt.
as long as they do it accurately.
Okay, and that accuracy is defined. Okay.
So, I'll give you an example. A lot is made of so-called sensational comments by judges in
Yes,
court.
exactly. That's what I wanted to
But
ask.
when
Yeah.
journalists go fighting over the order and they look at the order, it's a one-line order.
Yeah, exactly.
Because where is all that?
Mm-hmm.
None of that is recorded in Indian courts. In American courts, a transcript is
Made.
made by a court reporter. So every word spoken is recorded
Okay.
in America, in England, in other countries. In India, there is a lot of back and forth. Courts express their views. What is recorded in a judgment or order. That's not a part of the proceeding. That has no bearing. Sometimes judges just vent their feelings. Sometimes judges make statements. Sometimes there are ill-advised statements. Press reports on it. Never contempt.
Okay. That's
Why?
interesting. Why?
Because judges are intelligent enough to understand that this is not contempt. As I said, no. The first few paragraphs in grounds of appeal is the judge's finding is perverse.
The
He
appellate
failed to
language.
apply his mind.
Yeah.
I mean, you're not only using. So, the use of invectives or abusive language for judges. Now, all of this is a contempt jurisdiction is something that's undergone change. Because, as the Supreme Court recently says, the court should have a thicker skin. We are aware that we are going to be criticized. We are criticized as it is every day. But at the same time, where your actions tend to lower the confidence in the judicial system, that's a serious problem. And that's where the contempt of court jurisdiction comes into play. Generally. Has contempt of court's jurisdiction been misused? Certainly. But by far and large, courts are very careful about exercising
That
the
right.
contempt
Yeah.
of court jurisdiction. But it's certainly a potent tool. And it tells people that you cannot willfully say things to lessen public confidence or call into question or vitiate a proceeding, right? Which will then result in a miscarriage of justice. The law will punish you for that. That's basically the contempt of court.
Is this true that there is a saying which I don't know if it's a saying, but some people say that a judgment can be criticized, but the judge cannot be criticized. Is this true?
No, I believe a judgment can be, a judge could be criticized, but with circumspection and respect.
Okay, they can be.
Yes.
If the
Yes. For instance, I could say that I pulled out 50 judgments of this judge, and according to the statistics, the judge leans towards this part of the law and not this part. As a critique, he should be unbiased. That's not punishable.
Okay, that's not punishable. Okay, but if you cross a certain line, then that
Yes.
that is obviously okay. Okay, so that's all I wanted to ask regarding this. We're almost 1.5 hours along in the conversation.
Time flies.
So yeah, first time I'm discussing law with, and that's one of my things that an experienced lawyer is in front of me, and I got.
You might have to put some peppy music in the background so people.
Will I have a copyright infringement on that? That's I'll
yeah.
give you a call and I'll ask you, can I use this music?
Anytime.
Yeah. So thank you so much, sir, for this conversation. And hope sometime again, if I have a question regarding IP law, we can have a podcast again on this. I hope you had a good time.
Thank you
so much. Thank you so much for this
Thank you so
conversation.
much.
I
Really enjoyable.
Yeah, I really
Thank
enjoyed
you.
it. Thank you so much. Thank you.